Well, good evening, everybody. My name is Dan Urban. I'm a SCORE mentor, and I'm going to briefly talk about SCORE Cleveland, and then we're going to go right to our program with Tyler Bruley, who's an attorney, and he'll be talking about intellectual property for small business. SCORE is the largest network of free volunteer small business mentors in the nation. And so no matter what stage your business is in, at SCORE, we have a mentor for you, and you can easily request a mentor to help you start, grow, or transition your business today. At the end of this presentation, I'll be showing you a couple of QR codes. So one of them will allow you to get the URL, the web link for our website, and the other one will allow you to go right to the form that allows you to request a mentor. So keep an eye out for those at the end. SCORE's mission is to foster vibrant small business communities through mentoring and education. We aim to give every person the support they need to thrive as a small business owner. Small business drives our national economy through business formation, job creation, and wealth building. And small businesses are critical to vibrant communities in our society. SCORE mentors give our volunteers. We give freely of our time, energy, and knowledge to help others. We have an open door policy. Anyone who has a small business can come through it, and we empower all entrepreneurs to succeed. In 2022, SCORE Cleveland was named Chapter of the Year among basically 250 chapters nationwide, 12,000 people. We had helped start 501 new businesses. 808 jobs were created, and there were over 7,500 interactions with clients. We serve a 7-county region, which is Cuyahoga, Lake, Lorraine, Geauga, Ashtabula, Huron, and Erie counties. Our business is supported by the U.S. Small Business Administration, and we deliver all of our services at no charge. This is our website, so when you see this, when you use that QR code that I'm going to show you in a minute, this is what you'll see, and we have a number of ways that you can interact with us on the top menu bar. Never did that. Okay, so here are the QR codes. So get your phone out and get your camera up and snap the one on the left. We'll give you the link to that homepage that I just showed you, and the one on the right, if you're so inclined and are interested, you can request a SCORE mentor. It will take you to a form. So I'm going to give everybody a few seconds to get their phones out and snap those if you so desire, and then I'm going to turn it over to Tyler. So Tyler, I'm going to turn this over to you.
All right, let's see if I can share my screen here. That should do it. Oh, it always does this. I want to get these notes off. Nope. Oop. I was hoping I could remove the hide presenter view. In the beginning, I'm not sure if it's looking at the right screen or not.
Tyler, in the lower right, where you see a slider bar just to the left that has a little icon on the lower right of your screen.
Yep.
Next one over on the right. Go right. No, on the right. Click that.
Yeah. Are you guys seeing all the like extra?
Yeah, we are seeing.
Yeah, that's what I was trying to undo. Because when I did this last time, I was hoping to undo that, but I'm not sure it's gonna let me. So
Well, if you're comfortable just doing it this way, I'm sure nobody's going to object.
yeah. So you guys can see it then. Okay.
Yeah.
Okay. Alrighty. So it's going to be intellectual property for with basics, and it's going to be focused on business folks and people who just need to know enough about intellectual property and how it affects their business. Right? We're not going to talk about super specifics or anything like that. Um, it's really going to be a basics presentation. I got to give my legal disclaimer to start. This is for general educational purposes only. It's not legal advice. There will be no attorney-client relationship established here tonight, and you should consult your own attorney about each of your own very specific legal issues. And so, as I was saying, what to expect in this presentation? Well, first and foremost, I'm a business lawyer. I have practiced in-house counsel, so inside a company, as well as at a firm, a law firm. And I'm actually back now in-house for a real estate developer in Cleveland. And most of my practice is focused on real estate and general business, corporate law, commercial real estate, that is. And but I also, when I was at the firm, also dabbled in intellectual property. I'm not a patent attorney by any means, but I'm going to talk basic patent law, and how to get a patent. We won't go into IP filing requirements, infringement, defenses, except very briefly in terms of defenses. And honestly, if you're at those stages, you should already be talking to an attorney. And certainly SCORE has referral networks as well as the CMBA, the Cleveland Metropolitan Bar Association. But really the presentation is going to be from the approach of what should matter to you as a business owner in regards to IP, and sort of what landmines once we get through talking about the various areas of intellectual property, what things you should maybe be thinking about, concerned about, as well, and just briefly at the end. And as I mentioned, I'm not your attorney. We're not going to get into specific answers to your specific IP issues tonight. We'll talk generally about things, but don't go asking the hypothetical question that is just hypothetical, but actually your exact scenario, because I'm not going to be able to answer those questions. All right, so let's start with what is intellectual property. I've already been talking about IP and saying the words intellectual property. What does that even mean? I think the easiest way to think of it is that it's an intangible. It's not tangible. So they can be fixed in a tangible. And so what do I mean by that? So for example, an idea, right? Copyright. I have this idea of this, play or this book and this manuscript, and it's an idea, right? It's tangible, and my rights in it are intangible. But the book that I put it in is a tangible, so it can be fixed in a tangible medium, but it's an intangible, meaning it's those rights in the intellectual property itself. So what does all that mean? Rights and intangibles is how I would think about it. So these are the four main categories we're going to talk about tonight. Patents, trademarks, copyright, and trade secrets. And under patents, we're going to briefly talk about utility patents and design patents. There are also plant patents, but we're not going to talk about those. There are a couple other areas of intellectual property that we're not going to discuss tonight. Things like mask works, which are like a series of images that you can get for like circuitry, and I don't even understand it fully. That's a very basic description of it, but we're not going to talk about that tonight. So, patents, there's utility and design. Utility patents are going to be your useful inventions. We're going to talk about, what novel, non-obvious means, and those things that, and what type of things might be be patentable. Design patents as well, what those are. Trademarks, those are going to be your names, brands, symbols, slogans, colors, sounds, packages, and store designs. So we'll get into that. Copyright. these are going to be original works or expression in diverse categories. So those can be things like literary works, or they can be as different as computer software you can get copyrights on. And then trade secrets, we're also going to talk about business, financial, and technical information. And it's all about keeping it secret, right? So if you keep it secret, what kind of rights can you maintain there? And what type of things does that apply to? The number one thing people think of are usually recipes for trade secrets. So these are a few examples of each. There's a design patent, a utility patent, images here, which we'll go in more detail later. Your trademarks, so Amazon.com, Coca-Cola, Just Do It. This is actually, Pullman Brown is actually a color trademark. You can trademark colors. It is very rare to get a trademark on a color. But it is possible. So Pullman Brown, Tiffany Blue, those kinds of things. And Energy Star, that's another one. And then copyright, so books, music, photos are the ones people think of most. And then, as I said before, trade secrets, Coca-Cola's, or at least a alleged picture of Coca-Cola's recipe. So patents, jumping right in. They don't, so unlike trademark and copyright protection, which we're going to talk about, which have common law protections, meaning that you don't have to register them to have protections. Patents are not like that. They do not come into existence the moment of creation or use, but instead you have to persuade the U.S. Patent and Trademark Office, the USPTO. And they're made up of claims which define the extent of the protection conferred by a patent. So there'll be a whole list of, if you looked at a patent online, you'd see like some pictures, you'd see a table of contents, and then you'd see all these little bullet points and numbered that go down through, and they're very technical and very confusing to read as from a layperson, but they essentially outline the borders by which your invention is defined. Right? So it goes through and gives exceptions, and it'll give these claims of what you're claiming is protected and unique and protectable under patent law. So laws of nature, natural phenomena, abstract ideas, simple mathematical formula are all going to be exempt from patent eligibility, things that are just out there, right? And you cannot, you can get both a design and utility patent for the same thing. And can also get a design patent and copyright. There are unique scenarios where you might want to do that. So utility patents protect useful inventions that are novel or new and non-obvious. And so those are things like processes, machines, manufactured goods, chemical, biological, or other compositions of matter, and improvements to any of those things. So you can add on to some of them. But as we'll see, you can't just make an incremental advance to something. It does have to be something truly an actual improvement. And utility patents are good for a maximum duration of 20 years from the filing date of the earliest U.S. patent application. So that's important, that it's from the filing date of the earliest U.S. patent application. So I said they've got to be useful, novel, and non-obvious. So these are the questions you have to ask. Useful, it can be difficult to overcome, especially in software or medical applications, but you ask yourself two questions. One, does the invention work in the sense of, does it do the thing that I say it does? So is it actually like doing something? I could create an object and say, this is, this great product that does these things, but it doesn't actually do it, then it's not going to be eligible for patent protection. And two, if not, does the thing it does benefit society in some way? So novel, is it new? One of the term, the legal term, is it prior art is how they'll refer to it in the patent world. And prior art subtypes are: one, prior knowledge of the invention in this country; two, prior use of the invention in this country; three, prior patent in any country; and four, prior printed publication in any country. Those are what we would say are not new. Non-obvious. And as I said before, it must be more than an incremental advance. It must be invented. And this is one of those things that's most litigated now, and is a factor test. And as you'll see throughout this presentation, anything that's a factor test it's a toss-up, right? That's just how it is in many fields in law, and that courts have factor tests to determine things, and so they weigh things, right? Another good example of it is the IRS's independent contractor versus worker factor test, right? Of weighing whether that person is an independent contractor or whether they're truly an employee. And there's a whole list of factors, and again, it's highly litigated. So here's an example of the first page of a US patent. This is a Steve Jobs Apple patent. And it looks like it's for some kind of portable media device or remote that maybe he's got like some USB thing here. And so these are the couple of drawings. There'll be an abstract, as I said. And then after this page, it'll start into the claims and exceptions to claims. And you can look up all patents in the US, applications, filings for them, everything, all on the USPTO's website. And this was an example of a utility patent. We're going to move to design patents now. I'll have the example of that as well. You can kind of see the differences. Design patents apply to new, original, and ornamental designs of manufactured articles, which can be subject to copyright and trademark protection, known as registered designs in other jurisdictions. It must give a peculiar, distinctive appearance to manufacture or article to which it may be applied to, or to which it gives form. And this new design should enhance saleable value, enlarge demand, and provide a meritorious service to the public. That's what you've got to have in order to get these design patents published. And it's good for 14 years versus a utility patent for 20. And this is sort of what your design patent, this is again, I think a Steve Jobs, Apple patent. I think this is for their like outlet charger that like folds closed. And so, all outlet chargers, right, aren't something new, but this idea of this foldable design is unique and helpful. And, it's peculiar, it's distinctive, right? This is what design patents are oriented towards. And so you can see the claim, ornamental design for a power adapter as shown as described. And then there's a whole description of the figures. And then there's more claims and drawings after that. Okay. Patent priority. So first to file, who will receive the patent. So that's, there for trademark and copyright, it's a little bit different. But for patent priority, meaning who's in line first matters, right? So first to file with the USPTO, because like we talked about earlier, you don't get any rights automatically. So this is all first to file. Unless, and these are your two exceptions, the claimed invention was patented, described in a printed publication, or in public use, on sale, or otherwise available to the public before the effective filing date of the claimed invention. So essentially, if it's already out there, right? And then, or the claimed invention was described in a patent or in an application for the patent that names another inventor, it was effectively filed before the effective filing date of the claimed invention. So if somebody else beat you to the filing. Important dates, public use. A public use for the purpose of barring access to the patent system is a use more than a year before the patent filing date, whereby a completed invention is used in public without restriction and in circumstances other than substantially for the purposes of experiment. And then on sale, where an inventor has offered his invention for sale, he has 1 year from the offer date to file for a patent application. Failure to do so constitutes a complete statutory bar to patent protection. So this is where, look, if once you've got your thing out there, you've got a year. So if you sell this thing have this thing for sale to the public and you haven't had a patent on it and haven't filed anything with the USPTO, you only have a year from that published date, or it's a complete statutory bar. You will not ever get patent protection on it after that. And certainly you don't want to leave it out there for somebody else to file on it as well. So it's really important to keep these things secret until you file. So what do you get for all of this? The right to preclude others from making, importing, selling, or using the invention for 20 years. That's what you get. You hear about it with prescription drug manufacturers. It's on patent, off patent, right? You get 20 years. The patent negatives, it's expensive to file. Those patent applications are very highly technical. There is a whole subset of lawyers that do that. You actually have to pass a separate bar exam to be a patent attorney. You have to have, either some sort of science, engineering background degree to do these kinds of things. And it's not cheap to hire those people. And they're also expensive to enforce. So, if somebody's infringing on it, the government doesn't go after them for you. You have to then go after them yourself. And it can take years to get a patent. This is not a quick process. It's slow, and it's a back and forth between the USPTO and you. So moving on, copyrights. Copyright does not protect an idea. So remember we were talking about intangibles, fixing them in a tangible medium. And so it's only the expression of an idea. So note that this does not protect your idea of an invention, only the way in which it is expressed. So what I mean by that in parentheses is that if you write down what your invention is that might be patentable, right? It's only going to protect that writing of it. It's not going to protect necessarily your that patentable invention itself. So be very careful there. And to be granted copyright protections, the work must be original, meaning that it entails at least some minimal degree of creativity. And copyright, as I said before, exists from the moment the work is created. So the moment I write a book, I have some copyright protection on it. However, you do have to register if you want to bring a lawsuit for infringement of your work. So just because I have the copyright, I have very limited rights in it. Yes, I own it, and I can keep it that way forever. But if I ever want to go enforce my copyright against somebody else who's copied my book and is now selling it to somebody, then I'm going to need to register it with the USPTO, and then go and bring a lawsuit against them. Again, those things aren't cheap. Registered works may be eligible for statutory damages and attorney's fees in successful litigation. So that's what you get out of that. And if registration occurs within the first 5 years of publication, so let's say I write my book, I've got it out there, right? I'm selling it to people. And then within 5 years, I go and get it registered. It's considered prima facie evidence in a court of law. Basically, it's a lower burden. Cherry burden. How long do you get it? The term is the author's life. So in this example, my book example, if I wrote my book, it'd be my life, and I pass away plus 70 years. So my estate gets it for 70 years. So one of the ones that you hear about famously in the news is the Disney Mickey Mouse copyrights. And I think some of the early iterations of Mickey Mouse are coming off copyright. But it's only going to be some of those early iterations, right? Because it's been so long. And then copyright notice. So, you see those little C's in the 2001, then maybe a company name, all rights reserved. So copyright notice is optional, but suggested to put others on notice that it is yours and you do have a copyright on it. It's sort of the scare tactic, I suppose. And so the example here, copyright, it's got the C 2001, which would be the initial first publication date, and then date of revision. So if you made additional revisions to the work, those are additional dates you would want there, and then the company name that owns the copyright. So expression of software code is protected by copyright, as we said, but not the functions of the actual software. The DMCA, which is an act that came out, the Digital Millennial Copyright Act, came out more recently, made it illegal to circumvent technical protection measures. So like encryption, if you have a published copyrightable work online, they made it illegal for basically additional penalties for you to circumvent that encryption and copy the work. So additional criminal and punitive penalties. So on to joint works. So you created the work with somebody else. A work prepared by two or more authors with the intention that their contributions be merged into inseparable or interdependent parts of a unitary whole, right? You write a book with somebody. You both contribute to it, but the whole thing is copyrighted together. And copyright in a work protected under this title vests initially in the author or authors of the work, and the authors of a joint work are co-owners of the copyright. And the dispositive inquiry of whether it is a joint work is whether the parties intended to be joint authors. So you look at factors like all participants were of the mind to participate and all participants contributed something inherently copyrightable. And any owner can authorize non-exclusive use without permission from others unless it damages the work. But the profits must be split proportionally on a joint work. Works made for hire. This is particularly important for small businesses. So you can imagine a situation where you hire somebody to do some work for you, but you don't get the copyright on it, or they retain the copyright, right? You go and get wedding photographs, right? And you look at the photographer's contract, it might say they grant you a limited license to use the photographs, but you don't own the copyright and you can't sell them, can't change them, do whatever with them. So this is important for small businesses who may get professional photos taken for their business and want to use them commercially. You got to make sure that these kinds of things are covered in those agreements. So work made for hire is one, a work prepared by an employee within the scope of his or her employment, or two, a work specially ordered or commissioned. Those are all the subsets of them. And if the parties expressly agree in a written instrument, what I was talking about, signed by them, that the work shall be considered a work made for hire. So it's the third prong that it could be a work made for hire versus not. If your work satisfies either prong, then the employer or other person whom the work was made for owns the copyright title. All right. Copyright infringement. So in order to prove copyright infringement, you must show substantial similarity and access or evidence of actual copy. Material amount of expression. It can still be infringement if it has the same plot, theme, dialogue, mood, setting, characters, etc. And you don't have to have intent to infringe on copyright. And one of the big common misconceptions is, oh, I didn't sell the copied work, so it's not copyright infringement. Wrong. No, you can face civil and criminal penalties for that stuff as well. And there's also contributory and vicarious infringement that does exist. So there are defenses, though. This is the one area I said we'll talk about the defenses that you can raise if you're ever accused of copyright infringement. Of course, though, it's a factor test, as one of my professors would say, and as I alluded to earlier, those are usually clear as mud. They're not clear at all. So the factors are the purpose and character of the use, the nature of the copyrighted work, the amount and substantiality of the portion used in relation to the work as a whole, and the effect of the use upon the potential market for or the value of the copyrighted work. Typically, you hear in like education, so so if you're looking at the purpose and the character, right? Okay, we're doing it for education purposes. We're trying to, help people learn. Maybe the nature of the copyrighted work is educational, and the amount and substantiality of the portion used in relation to the work as a whole. Maybe we're only looking at an excerpt of this one book, and we're, criticizing it and commenting on it, and so we've copied the book, but we're not really doing. We're certainly not commercializing it. And our little classroom is not going to have a big effect on the potential market or the value of the copyrighted work. Although there has been arguments when teachers are copying like textbooks and stuff like that, that's does have an effect on potential market for the work. But yeah, so it's going to depend on the industry of these factors, and in which are going to be weighed more than less. But your typical examples are going to be criticism, comment, news reporting, teaching, scholarship, research. That's what's going to be okay to copy, at least portions of copyrightable works. All right, trademarks, moving right along. So trademarks are a word, name, symbol, device, or other designation, or a combination of such designation that is distinctive of a person's goods or services, and that is used in a manner that identifies those goods or services and distinguishes them from the goods and services or other. Okay, so what does that all mean, right? It's a big, jumbly, long sentence. Essentially, I think of it as word or phrase that's distinctive of what you're selling, whether it's goods or services. And it's used in a manner to help identify those in the market, right? So let's just take an example. Coca-Cola, right? Trademarked name. They're using it for a drink, so it's that type of good, and they're using it to identify their goods, their soft drink, over that of other people's, Pepsi, RC Cola, whoever else, right? They're trying to tell everybody that when you get this is what you're going to get, right? You're going to get that delicious taste of Coca-Cola. You're not going to get anything else, and it's distinguishing them from other goods. It can't be a functional element. That's reserved for patents. But they can be logos, words, certification marks. So that's that Energy Star thing we were looking at earlier, right? It tells you, it's this certain certification, right? So it might not refer to a specific type of goods or specific goods owned by it, but it gives you that sense that these goods are better than and distinguished from other goods that are not Energy Star certified. It can be trade dress, so the packaging for Coca-Cola, or the product design, the design of the can or what have you. You can use, as with copyright, you get common law protections right off the bat, and you can use TM to identify your trademark. But you can only use the R with the circle, which is registered, to identify a registered trademark. So that's after you go through the USPTO process to register your trademark. So as I said before, once a merchant adopts and begins using a given device as a trademark, it does not have to take any further steps to protect the mark, as its rights accrue to the first senior user automatically. So what does that mean? All right, well, let's say I have a t-shirt business and I'm selling Tyler's t-shirts, right? That's my trademark. It's not a great trademark. Maybe something a little bit Zany's tees, right? That's kind of weird, right? Zany. Zany's tees, and I'm selling this cool design and everything t-shirt. And so Zany's is my logo, right? And I'm selling all these different kinds of t-shirts in just Cleveland. And so I'll immediately have, I could have a trademark on Zany's, but it's limited to Cleveland, limited to that geographic area, and it's going to be limited to t-shirts, or maybe slightly out of that, like apparel. So if somebody else comes into Cleveland and is selling Zany's sodas, I'm not going to have any rights to tell them that they can't, and they're not going to have any rights to tell me that I can't. It's limited to the particular channel of goods and services. And it's also limited geographically. So somebody could also do Zany's tees in Atlanta, because I haven't registered anything. I'm not selling in Atlanta. I never have sold in Atlanta. And so we can both coexist like that. Both of us then will also have troubles, or might have to have exceptions if we go and then try and register our trademarks. You got to be careful with that kind of thing. So as I said, protection is limited to the area in which a merchant is actually conducting business and a zone of reasonable expansion surrounding that area. So if I got Cleveland, maybe I get some greater Cleveland too. The first use of a mark in a given market for a particular set of goods and services gets priority. So you got to be first to use it. Just because you have the idea and maybe you've shown it to one person. That's not enough. You actually need to be using it in commerce. Requires bona fide sales of goods or services bearing the mark and limited to a category of goods, all of what I was just talking about. So you can go and register it though. There is both state registration, which will give you protection in the entire state, and there's federal registration protection in the entire country. Federal law provides for intent to use registration. So if you come up with an idea and you're not really, you aren't going to use it in commerce yet, so you're not going to get your rights off the bat, you can file for intent to use registration. And so that sort of reserves the mark for you, but it doesn't give you any substantive rights. And once registered, a trademark becomes incontestable after 5 years. So you do have like a 5-year period there. So here's one of the examples from the USPTO. Just do it. So it's going to describe what the mark is, give the picture of it, and then it's going to say the classes of goods and services that it's in. So these IC 009, IC 035, IC 041, those are classes of goods. And then it'll tell you what they are, right? So just do it. They've got eyewear, bags, sports bags, backpacks. They've got merchandise, clothing, apparel. Looks like they've got some virtual stuff, entertainment, sports equipment, that kind of stuff. What you would think that Nike Just Do It would have it in, right? But it's not everything, right? So other people can use this mark as Just Do It on other areas outside of these channels. So you'll see the filing date, you'll see who owns it, who their attorney is, those kinds of things, whether it's live or dead. All of these things can be searched online. So, when we go to file names for companies, we'll look and see, okay, does this person, has the name? We'll do a basic Google search. To see if the company name's being used anywhere on anything. We'll look on Secretary of State's websites, and then we'll also search USPTO basically. There are programs for fees that you can use called there's one called Markify, and you can get a whole report back that's 500 pages of your proposed mark, and it'll go through every website, every domain. It'll search the whole web, a whole bunch of databases, everything and anything you can imagine, to give a really good idea of whether the mark's being used or not, and then can give you an idea of whether you might be able to register a trademark. Because there's nothing worse than coming up with a great name, filing with the Secretary of State, and just because it clears with the Secretary of State as your company name or your doing business as name, doesn't mean that it's not violating somebody else's trademark. And so you get there, 5 years down the road, and you're like, somebody shows them and says, "That's a nice trademark you got, but I've had it first, and I've been using it longer than you have, and you need to cease and desist." Not great, right? You've invested all this time and energy into the mark, and now you've got to change your mark. So trademarks, generic or descriptive terms are not going to be allowed trademark protection. Bad examples are things that are just, describing the product, right? White glue, right? Just got basic descriptions. You're not going to be able to get trademark protection on that. However, so Apple as an identifier for apples, not great. Or Vision Center, right? You're not going to get trademarks on those unless you can show some sort of secondary meaning, for example, 7-Eleven. And it's a factor test for secondary meaning, because everything's a factor test. The best trademarks are fanciful, arbitrary, or suggestive, unless they become the generic term for something. For example, thermos, or because thermos is a brand name, but now everybody knows that when we say thermos, we mean that insulated mug, right? That's got the cap on it. And so sometimes those trademarks can go out of protection when they become too generic. So some good examples of that, I think, are like Velcro. I think they lost that. Maybe even Q-tip. I don't know if they still have theirs. But those are the types of things that you have to be careful with. Kleenex, that brand names that became descriptions for the products that we know now. So what is suggestive? Things like copper tone or greyhound. Arbitrary and fanciful are going to be things like Apple computers. So apples have nothing to do with computers, right? Or King Arthur flour. King Arthur has nothing to do with the manufacturing of flour, right? And grounds for rejection are things that are scandalous, deceptive, geographically misdirecting. All right, on to trade secrets. All right, so trade secrets are going to be information including scientific or technical information, process, procedure, formula, etc. that meets two parts of a two-part test, another two-part test. Something is a trade secret if it is information that derives from value from being kept secret, and two, information that has been subject to reasonable efforts to maintain secrets. So is it a secret, and do you derive value from it being secret, and have you kept reasonable efforts to maintain its secrecy? Like I mentioned, Coca-Cola, fracking liquid. That was a big one in the news a number of years back. That the liquid recipe that they used to inject into the earth to get the natural gas out through fracking was a trade secret. It can also be things like customer lists. You hear about that a lot, or processes like Google's search algorithm. And so these are really great for small businesses, just like sort of common law copyright and common law trademarks, because you don't really have to do anything to get the protection. It's just keep it secret. And that it actually has to derive value from being kept secret. So, when you're deciding as a small business of what, where you want to allocate your resources, you're not going to want to spend on the areas you don't need to, right? But there are important things that, you need to do in order to keep your trade secrets, right? So like customer lists and things like that, or recipes for your bakery. It's important that, you limit the people who know these things, you keep them secure. And then if you do have employees that know them, make sure there's specific agreements in place that say, you can't take this stuff with you. It's a violation. These are trade secrets. We consider them trade secrets. They must be kept confidential. These are the protections you need to take in order to keep them confidential. And typically this, like I said, it involves your relationship between the employer and the employee. And the best part about trade secrets is that there's no time limit on protection versus patenting, something which does have those time limits, and copyright, which does have those time limits. So there's 3 scenarios, though, when trade secrets can conflict with patents. One in which if an invention is clearly unpatentable, a trade secret doesn't cost us anything. These inventions wouldn't be in the patent system anyways. It doesn't take away anything from the public. 2, if an invention is clearly patentable, the inventors will get a patent because the monopoly and protections are so much stronger. It protects against even things like reverse engineering. And 3, if there is uncertainty as to the patentability of some inventions, trade secret law is helpful to keep these inventions from clogging up the patent system. And then other IP concerns. Contracts. Next week, I will be doing a presentation on business contracts where we'll talk about all the different kinds of clauses in contracts, various contracts, and then we'll talk about a few select provisions, things like indemnity, things like intellectual property assignments, stuff like that. So as I was saying already, if you're sharing your IP with somebody, it's really important to have, especially if it's something patentable or it's a trade secret, it's really important to have confidentiality, non-disclosure agreements in place with those people before you talk about any of this stuff. And then making sure that you're properly, having good security precautions, protocols, making sure this stuff's protected. All right, I need to know more about IP, or I have a specific IP issue. The USPTO's website and the copyright website are both really, really good. I'd say over the last like 5 to 10 years, the USPTO has done a really, really good job of coming up with a whole slew of educational materials, videos. They've got like whole courses. And so, if you enjoyed this and you want to learn more about one of these specific areas, I really would invite you to go to the USPTO website and drill down into there, and there's just so much stuff there. And then if you do need an attorney, Cleveland Metropolitan Bar Association or SCORE can both help refer you to an attorney based on whatever your specific need is. And as I said, you can join me next week where I'll discuss different contract provisions and what they mean, including those regarding IP. And that is all I have today. So that is the end of my presentation. I thank you for your time, and I think we're going to take some questions, if there are any. Dan, any questions?
No, I don't have any questions. We'll give it a minute. People might be giving us some thoughts. So let's just see if anyone does have some questions. A lot of material, but very important material. And as I mentioned at the beginning of the session, everyone who's registered and attending will get a link to the slides. It'll be on our website, or the SCORE website. Also, it will be in the SCORE YouTube channel. So you're welcome to probably early next week. It takes our editor a day or two to get this done. And then you can watch it at your leisure. So we'll give another minute for questions and see if there are any. You can put them in the chat and welcome your thoughts. Well, there we go. Here's a question.
Good question. So the question is, what is the website to go to check if anyone has your trademarks? So you can go to the USPTO's website. There's a link. Let me just give you the best way to get there. So if you go to uspto.gov and there's a little trademark drop down, there is, let's see the search here. Tease. So anyways, on the trademark website, if you go to the trademark section, there is a search. So if you click on the trademark tab, and then it says there's like 6 things. It says search trademarks. You can search in a few different ways. It is a very tricky platform to use, so I would recommend staying in the basic section. However, that as we talked about, that doesn't mean that somebody isn't using it. So I would also recommend, Google, Secretary of State's websites to make sure business names aren't named after them. And then, if it's a mark you're thinking about trademarking and using as your own brand name, then you should really be doing some more comprehensive search. So sort of what I mentioned earlier, which is there's companies called Markify, which does like a super huge, crazy, comprehensive 500-page search to see if anybody's using it in commerce. So that's how you go about that.
So final call for questions. We didn't get any during that last chat, so I'm going to thank you very much, Tyler, for a great presentation. Thank you, attendees, for your interest. And again, you can get this video on the SCORE website or on our YouTube channel. Probably this is Thursday, so early